Okay, so
Good afternoon.
yes, good afternoon, everybody. So obviously my name's Craig and this is Amy. We both work for Glanville Solicitors and our specialism is private clients. So it's wills, trusts, powers of attorney. So this is why we've been kindly invited to talk today.
Okay. So, we're going to run through powers of attorney with you and some kind of key aspects to consider, what they are, what kind of decisions can be made, why they're important to have in place. But we're going to start with a couple of kind of case studies from relevant experience from kind of our own experience, really. I think, Craig, do you want to?
Yeah, so I've got a couple. Well, one is my own personal experience as an attorney. So I was an attorney jointly and severally with my sister and my mother for my grandfather. So at the age of 98, he decided he needed some assistance with lasting powers of attorney, and it was actually quite useful because he retained capacity for the rest of his life, but it was really useful because you can set up lasting powers of attorney to not only assist when you lose mental capacity, but also if you have it, but have any physical impairments. So my grandfather was losing his sight, and at 98, he was becoming quite frail. So it was really useful to be able to get both types of lasting power of attorney in place, although we didn't use the health and welfare lasting power of attorney, but it just meant that I could take over and look after everything he wanted me to do with his permission. And it was really useful to be able to set up online accounts for paying utilities and sorting out, checking his bank statements to make sure that everything was all running and okay. So that's a good example where you might want to use a lasting power of attorney if you continue to have capacity. And we also have a case study where personal experience within the work sphere. And this is a particularly good example that highlights how useful lasting powers of attorney can be. And I had clients, a married couple, who set up lasting powers of attorney a few years back, and um, the there was a husband and wife, and the wife sadly lost capacity quite rapidly, and but it really highlighted that even as a married couple, lasting powers of attorney are really important because the husband was able to decide where she moved into care and was able, as the attorney, to also fund the care and continue paying anything in her sole name. So he was able to completely look after her best interests when the time came, and it was a seamless experience for him, although very difficult having to live with that situation. It was one pressure that was taken off because it just meant you could get on and do the job as the attorney. So there's just a couple of examples there where we had what with my family experience where he maintained capacity, but also if somebody, the donor, the person who makes lasting powers of attorney loses capacity in the future.
Yeah. Next thing, moving on from that, is basically what a power of attorney is. So it is a legal document that allows people you choose, to act as your attorneys to make decisions on your behalf. So key examples of when someone has lost capacity, they need that assistance for someone to take over and deal with their finances or make decisions regarding their health and welfare. So that's where it's really important, because all the while you've got capacity, you have the opportunity to put powers of attorney in place and appoint people that you would trust to deal with your affairs if you're not in a position to do so yourself. Sadly, if you lose capacity and don't have a power of attorney in place, that option is then it's not available. Essentially, you can only do a power of attorney and prepare one all the while you've got capacity. But also, from what Craig was saying, a power of attorney for the property and financial affairs side of things is particularly helpful, even if you've still got mental capacity, but it's a physical incapacity. So taking, I don't know, a stroke, for example, actually mentally you're okay and you're still able to make decisions, but physically it might be something that you've lost the use of being able to write with a pen, and so you can't physically sign something anymore. And it could be a temporary thing. So if you've gone into hospital for an operation, and so you're going to be recovering in hospital for a while, not physically being able to get to the bank to withdraw some money, pay bills, that sort of thing, the power of attorney is really useful in those situations as well. So that's why it's always, really key to have, because if you don't have that option and the flexibility in place, it just limits how much you can do and how much other people can do on your behalf. So the types of powers of attorney that there are, as we've kind of already touched on, but property and financial affairs. So that essentially you're giving your attorneys the authority to deal with your property. So if, for example, you needed to or wanted to move and downsize, or you were moving into a care home, you can give your attorneys the authority to deal with the sale on your behalf. So again, if you've lost capacity, you're not going to be able to sign all the legal paperwork to facilitate the sale. So your attorneys can do that on your behalf. But also, if you've still got capacity and you just a bit overwhelmed, maybe perhaps dealing with the legal paperwork, you can ask your attorneys to do so at your direction. So deals with any kind of property related matters, but with your finances as well. Essentially, your attorneys can make any decisions that you would ordinarily make for yourself. So banking, who you bank with, bills, pensions, any investments you've got. You're essentially authorising your attorneys to assist or make those decisions on your behalf, which is why it's really key that you appoint people that you trust, and that obviously know you and know what your wishes are. And then the health and welfare.
So yes, the health and welfare, they do tend to work hand in hand. So the health and welfare covers your health and welfare decisions, but it's only if you lose mental capacity. And that might be a temporary loss or a permanent loss, but it deals with where you live, what treatments you receive, even to what foods you eat. So your attorneys can, if they know what food needs to be avoided, for instance, they can ensure they do that. And it can also be very serious decisions about giving or refusing life-sustaining treatment. So if a decision needs to be made, you can set up the lasting power of attorney so that your attorneys can make that ultimate decision. So it gives you sort of so if you're concerned about, for instance, a doctor making that decision, somebody who doesn't really know you, then you can have your attorneys get involved. And there's also one other type of power of attorney we'll very briefly touch on. It's not really, it's known as a general power of attorney, and that it's generally set up on a temporary basis. So it's either if you need a power of attorney put in place urgently, it can deal with it temporarily while you're waiting for the lasting power of attorney to be registered. But also it can be set up for specific transactions, for instance, just for a one-time transaction, such as a property sale. But general powers of attorney aren't used very often, and it's really just for one-off,
really, isn't
yeah,
it?
and you can only use it whilst you have mental capacity. So, which is why lasting power of attorney generally is better to have in place. So, so just thought I'd briefly touch on that other power of attorney, but the main focus will be on the lasting powers of attorney.
Yeah, absolutely. So lasting powers of attorney, essentially they're governed by the Mental Capacity Act, which was put in place in 2005. So essentially, Mental Capacity Act is the bit of legislation that governs powers of attorney and everything capacity related. And so instances we see that a capacity issue can be fluctuating. It's rarely the case that one day you've got capacity and the next day you don't. Usually it's a sliding scale and it gradually begins to decline, but it can be fluctuating. So there might be some days that are better than others, and it also depends on the type of decisions that need to be made. So it might be that someone's capacity is fluctuating and that they can make more routine day-to-day decisions about paying a bill or withdrawing some cash from the bank, but any larger decisions such as where you live, whether the property needs to be sold, you don't have enough capacity to be able to make those decisions. And so that's where your attorneys would then assist you and always have to ensure basically acting in your best interests and assist you to try and make the decision for yourself. But if obviously you can't and it becomes clear that you can't, then your attorneys make that decision. But capacity can be a temporary thing. It might be for whatever reason that actually there's a period of time that it's temporary, and so your attorneys need to act for a period of a month or two, but then actually it's okay again, and so you can take back over dealing with your affairs. So it's very flexible, and that it's not a case of you put the power of attorney in place and you've lost all kind of control of everything. It's very much there to assist you, either when you say you want some help or when you can no longer make those decisions for yourself, and so your attorneys are needing to get involved. Kind of the key instances we find regarding incapacity are usually
it's usually medical diagnosis,
yeah,
or where something sudden happens, such as an accident. So good examples is a diagnosis of Alzheimer's or dementia, Parkinson's disease. Also, a stroke can cause either a temporary or a permanent loss of capacity. And if you're in a coma, so say you had an unfortunate car accident or something like that, and you were in a coma as a result, if you have a lasting power of attorney or lasting powers of attorney in place, then your attorneys can immediately step in and look after your best interest until you recover.
okay.
Okay, so then we move on to the choice of attorney. So I'll let you.
Yeah, so as I've kind of already touched on, that your choice of attorney is paramount, really. You need to be appointing people that you trust 100%, because the documents are brilliant and they're very flexible, but they also come with a lot of powers that can be made on your behalf. And so the people you're appointing, you've got to be people that know you, and are close to you, and you trust them completely, because they will be able to deal with your affairs in the same way that you would be able to. And so usually you get the case that the parents come in a lot of the time, and so they're appointing each other, so their spouse and then their children. It can be a bit more difficult if someone's coming in to see us and they don't have children, but there are ways around it. But trust is definitely the paramount importance of powers of attorney, because your attorneys have to act in your best interests at all times, and so you've got to be comfortable with who you decide to appoint, essentially. Usually it's not strictly necessary, but it's usually helpful to appoint people that are younger than you, so using children as an example, just that kind of that next generation down, but appreciating that's not always possible, and so it's not a big no that you can't appoint people of a similar age, but it's having that flexibility there, that hopefully you've got people there that are younger than you that can deal with your affairs, rather than relying on someone that's perhaps a bit older, and then we need to kind of jiggle around with the powers of attorney and who can act.
Yeah, and it's even a possibility that if you want, you can have two levels of appointments. So you can have primary attorneys who are acting for you in the first instance. So you may have people similar age to you or a spouse, and then you have your children or younger or other replacement attorneys who step in if they are unable to act. So it's quite a flexible document, and it can be set up to look after your interests as and set it up for what's best for your situation. So yes, but also possible for special attorneys to be appointed as well. So if there isn't anybody in particular that you either trust or family or friends that you wouldn't want to get involved, it is possible to appoint professional attorneys as your under your LPAs. Generally, it's only for the financial power of attorney, because generally you want to really, with health and welfare, it's very personal to you. So you want to really ideally appoint people who know you well. So for example, with our firm solicitors we work for, we generally only get involved with financial, property and financial affairs LPAs, because we of course can act impartially in ensuring that we do act in the person's best interest. But the health and welfare, we wouldn't necessarily know them well enough to be able to make that decision. But there's also useful to sort of just to highlight that if you did appoint professional attorneys, there is obviously a cost to that ongoing, because we would need to be working on a professional basis.
Yeah. Yeah. So looking at kind of what attorneys can and can't do. So for the property document, as we've kind of already touched on, your attorneys can make essentially any financial decisions that you would be able to make for yourself. So including the sale of your property, who you bank with, making investment decisions, looking at your benefits or pensions. So they can deal with all of that. But things that they can't do, so they can't change your will, because that is a personal document to you and only comes into effect on your death. So they can't make any changes to that. Also relating to gifting as well. In some instances, it depends on the level of gifting, that usually requires the court involvement, particularly if you've lost capacity. If your attorneys are looking to make quite large gifts on your behalf, they will need court approval to do that. But yeah, essentially any financial decisions you would make for yourself, your attorneys can do on your behalf. And then on the health and welfare.
Yeah, so with the health and welfare, essentially it can only, as I mentioned earlier, it can only be used if the donor, the person making the lasting power of attorney, lacks capacity. And it covers instances where you can decide, the attorneys can decide about what treatment you receive. As it's sort of mentioned this earlier, but also where you live, what food you eat, and continuing or ceasing life support or life sustaining treatment. You can also include specific preferences and instructions in the power of attorney, the health and welfare LPA, or you can include them in both. But you can specify certain circumstances how you wish to be treated. So it's essentially, you can give direction to your attorneys ahead of time as to how you want to be treated in certain situations. And you can impose restrictions about movement into residential care, for instance. So if you felt very strongly against being moved into care, it would only be a last resort situation where they could do that. So they could carry out your wishes as far as possible, to keep you at home if it's the best situation for you.
Yeah. Okay. So the next bit we're going to cover is common myths. So just some bits that we kind of thought about ahead of the meeting that we've experienced ourselves if clients have come in to see us. Just some comments they've made about things they think is the case or might not be the case. So starting with so a common myth is that you only need a financial power of attorney. Which isn't the case. It's extremely sensible to have both types in place for the reasons we've set out. And although they are individual and separate documents, they do complement each other quite well. So for instance, if you're looking at, I don't know, care fee funding, for example, your attorneys will need the financial power of attorney to work out what you can afford, and what your income and your capital is. But the health and welfare power of attorney to give them the authorities to where you then move or live. So whether that's you're staying at home and carers are coming into your home, or whether a decision needs to be made that you need to move into residential care. So although they're individual documents, they do complement each other quite well, because there are some middle grounds where actually having both documents in place is needed to make a decision.
Absolutely. So another common myth we have come across in the past is that spouses are able to act on each other's behalf without a lasting power of attorney in place. And unfortunately, it's not the case. Even if you have joint accounts in both the names, it is supposed to be the case that you lodge the power of attorney with the bank, because especially if one of the joint account holders loses capacity, it can cause issues. So there's not unfortunately a legal assumption that a spouse can act for the other in that situation.
Yeah. And the next kind of common myth we look at is that powers of attorney should only be set up upon a diagnosis. So if someone's recently been diagnosed with dementia, for example, actually putting these documents in place way beforehand is suggested and advised, it's really sensible to do so. It's a bit like having buildings insurance in place, so property insurance in place, and that you have it in place and you hope you never need to rely on it and make a claim, but it's there if you need to use it. And it's the same with powers of attorney. Set them up while you're willing and you're able to, and hopefully, all being well, you won't need to use them in the future, but if you do, they're there ready to go, and there's not then going to be any issues with trying to get something sorted on receipt of a diagnosis.
Yeah, and it's obviously important also to make clear that a diagnosis doesn't necessarily mean you can't make them. It's quite often a trigger point for somebody to approach us to assist with making LPAs, lasting powers of attorney, because which is absolutely fine. If it's depending on the stages of that diagnosis, it's perfectly able to assist there. But as Amy mentioned, it's quite a good idea, if possible, to get them set up well ahead of time. Another common myth is that if lasting powers of attorney are needed urgently, and it can sometimes be where somebody is progressively losing capacity at quite a fast rate. Applications cannot unfortunately be expedited. So the body who deals with the registration of lasting powers of attorney, they're called the Office of the Public Guardian, and everybody has to wait in the queue. So unfortunately, there's no queue jumping with the application process. At the moment, it's the guidance is around 10 weeks for registration. So if LPAs are needed urgently, you just have to wait, unfortunately. So again, another good reason, if you're able to, is to get lasting powers of attorney in place well ahead of time, so they can be used immediately if they're ever needed in the future.
Next one is looking at changing attorneys once the power of attorney has been made. If you are looking to remove someone as an attorney, you can do that by doing a partial revocation, but you can't add anyone once the document's in place. The only way to add another attorney is to do the documents again. So that's why it's quite crucial to make sure you're choosing people that you are very happy to appoint, and often more than one person as well, because if something happens to that one person, they can't act anymore and you don't have any attorneys left to act for you. So it's always best to have at least 2 attorneys appointed. But yes, you can partially revoke the power of attorney to remove an attorney, but you can't add anyone onto an existing document. You would have to start the process again. The next one is about the power of attorney being used once someone has died. So essentially the power of attorney ceases on death. And so once the donor, so the person that's created the power of attorney, has died, that the power of attorney should not be used at all. Your power under them has then ceased. And it is then the will and whoever the executors appointed in the will that then have the legal authority to deal with the estate and deal with the finances from there.
Another common myth is that we've had this a number of times where we've been approached by clients or inquiries, is that you don't need lasting powers of attorney if you have a will in place. And again, this it's very sort of the opposite of where what you've just mentioned, that the wills will be very much only when somebody has died. So they are both as important as each other, really, having the will in place to deal with your affairs when you've died, but also the lasting powers of attorney deal with your affairs during your lifetime. So but we've had on numerous occasions clients come to us asking whether they're necessary at all, but it's very much the case that LPAs are really important.
So moving on to what happens if you don't have a power of attorney in place and you have lost mental capacity. So as I said earlier on in the meeting, if you have lost capacity and you don't have a power of attorney in place already, you can't then create the documents. And so the only option is what is called a deputyship order. And essentially that is making an application to the court to become someone's deputy, and it's a completely different process. It's not necessarily the people you would choose to act for you that can make that application. And it's also a costly and timely process. So as Craig mentioned, the registration process for powers of attorney at the moment is about 10 weeks. But the application for a deputyship order to be granted, we are seeing on a couple of recent matters I've dealt with that it's been in excess of 12 months to get the deputyship order through. And in terms of fees, if a professional is involved in drafting the application, the fees are a lot higher, and also the fees for the court themselves is a lot higher for a deputyship than what it is for a power of attorney. And there's a different process that needs to be gone through, including kind of numerous forms. There's notifications of certain family members, depending on who's around you. And essentially, you're stuck in limbo a little bit if someone has lost capacity, and for example, if they're in a care home and the fees need to be paid, unfortunately there's no one there to pay the care fees until that deputyship order is approved. And so there's often a bit of a standstill situation where there are people ready and willing to be acting as deputies to handle someone's financial affairs, but they just don't have the legal authority until the deputyship order comes through. And so that creates a bit of a problem for everyone involved, really, because they're limited as to what can happen. With obviously powers of attorney, we've got the two types of powers of attorney. With deputyship, it's more common for a property and financial affairs order to be granted. We and again, it's been on a recent case that I've had, there is the option for a health and welfare deputyship order, but the court will not grant that unless there are specific or urgent reasons for it to be needed. So an example would be if someone has lost capacity and they need to have an operation of some sort, that would probably be a reason why a deputyship order for health and welfare would be approved. But if there is not an actual need at the moment for a decision to be made regarding health and welfare, then the court will not approve that document, and they will basically say you would need to reapply as and when it's necessary. So with deputyships, even though you've lost capacity and there's no one there to deal with your health and welfare, the court will not approve an order unless there is a really real reason that it needs to be approved for. So like an operation, for example. But if it's day to day where you're living and what treatment you receive, they are unlikely to make that order. Moving on to kind of costs and registration processes. So as we've kind of touched on already, the power of attorney is kind of looking at a 10-week turnaround at the moment for once the documents go on to the Office of the Public Guardian for registration. Deputyships are taking, as I say, at least 12 months to go through. The court registration fee, so that's you have to pay a court fee on registration regardless of which route you go down. For powers of attorney, it's currently £92 per document, unless there's a fee exemption or omission that you may be applicable for you. It would depend on your personal circumstances as to whether you would get a reduced rate in the court fee for the powers of attorney, but if not, it is £92 per document. If it was a deputyship order, the court fee is £421 at the moment, and there are then ongoing fees due to the court on an annual basis as well. I think that was
yeah. So that's the general cost, and obviously if you use professionals to prepare either the lasting powers of attorney or the deputyship application, there would be legal fees that would apply as well. But obviously, if any of you watching need any assistance with preparing lasting powers of attorney, Christine mentioned at the start of the talk that she'll kindly pass on our details. So if you have any inquiries or want to have a chat with us about looking to go forward, we can have a chat with you there.
Okay, and then just one final thing to cover off is in relation to powers of attorney. It is kind of a lengthy form, unfortunately, a lot of form filling and details to complete. But the Office of the Public Guardian are very strict on the order of signing. So there is a specific order in which the person doing the power of attorney needs to sign, their attorneys need to sign it. And so if it's not done in the correct order and dated in the correct order, the court will reject the application and make you do it again, essentially. So there is a strict order for signing, which when we're acting for clients, we then guide them through the process as to how it's then signed and sent off to the court.
It's also important to ensure the details on the lasting power of attorney are correct. It's quite a common case where if incorrect details are inputted, whether that's the person making the power of attorney or the attorneys themselves, if that's inputted incorrectly and it doesn't marry up with their ID documents, there will almost certainly be issues with using the lasting power of attorney on even if it's registered, because they won't marry up, and there's quite a possibility that it would be useless if it's not got the correct details. So ensuring everything is correct is key when setting up lasting powers of attorney.
Yeah, and also just following on from that point, if when signing the documents, for example, your attorney has when completing their addresses that maybe spelt it incorrectly and go and crosses it out, if it's not then initialed by them and the person creating the power of attorney and it's sent off to the court will reject the application and make the attorney re-sign. So it's got to be really careful if there is a mistake, and it might, as I say, might be just because someone's just spelt their address wrong, which happens quite a lot, unfortunately, but they just made a mistake when they're signing the document. They've crossed it out and have mentioned doing it. I've crossed it out and done it again. But if they've not initialed it, the court will send it back and ask the page or the document to be re-signed.
Yeah, so another sort of common mistake is, again, we touched on this earlier, but it's assuming the property and financial affairs LPA covers everything, because we see more often than not, especially years ago when powers of attorney, they've been in place since 2007. We've been able to make them since 2007. But I think there has been a common sort of misconception that the property and financial affairs LPA will cover everything you need. And obviously the health and welfare, as we've mentioned earlier, complements the financial, but also deals with separate decisions for the person who has made it. And then another common mistake is the way it's set up. So you can set up, if you have multiple attorneys appointed under a lasting power of attorney, you generally have to choose how they act. So you can either appoint them jointly and severally, which means they can act together or independently. So it creates a bit more flexibility there, which is quite useful if, say, one of the attorneys is on holiday and a decision needs to be made, the other attorney or attorneys can continue. But the issues can arise if and I've seen this a few times in my personal professional experience, where attorneys have been appointed on a joint basis, which means everybody has to agree, and one of the attorneys has died. So, and it does render depending on how it's set up, it can render the whole lasting power of attorney invalid, and it would lapse and you'd have to start again.
Yeah, so it's really crucial really to look at the options available and how your attorneys can act, because I think a lot of people probably don't realise that it sounds sensible to have a joint appointment, and so the attorneys have to make every decision together, but that can become a bit complicated in practice. As Craig said, if one of the attorneys is out of the country for 6 months, or they've gone on a around the world cruise, for example, a decision needs to be made. If it's a joint appointment, that decision can't be made if that attorney is abroad and can't be contacted. And yeah, as Craig said, if it's a joint appointment and one of your attorneys dies, the surviving attorneys can't continue to act. The document ceases effectively, and you would need to start again. Whereas the joint and several option for appointing attorneys offers a lot more flexibility, as Craig said, that if an attorney is abroad for 6 months and isn't contactable, then the other attorneys that are in the country can continue to make decisions. And if one of the attorneys dies, if it's a joint and several appointments, your surviving attorneys can continue to act. There wouldn't be any issues there. So it's quite crucial to look at the ways that the attorneys can be appointed, because often people don't necessarily realise with a joint appointment that it can have difficulties in the future.
So that's about it, really.
I think we've covered everything.
But we'll hand back to Christine.
Okay. Well, thank you very much, Craig and Amy, for presenting this very, very useful information. It's been very much appreciated. So thank you for covering all those points. Just a reminder to everyone else that a leaflet will be, which can be used as a reference, will be emailed to you all. And that will also include Amy and Craig's contact details, so you can get in contact if you have any questions afterwards. And also a recording of this session will be made available in due course. So we've all been given the gift of time. So just like to say thank you once again for attending. Very much appreciated. Thank you. Bye.
Thank you.
Thank you.